Get ready. 3, 2, 1, start. The petitioner was a Class 4 employee in the health department. According to the respondents, she was to retire on 31st July 2007 as her date of birth, according to the medical certificate, was 13th July 1947, and since she was allowed to continue beyond the said period, an order was passed on 7th January 2008 retiring her from service forthwith with a further direction of recovery of the amount of salary obtained by her after 31st July 2007. It is this order which is under challenge by the petitioner on the ground that the impugned order is founded on the strength of records which would not alter the status of the petitioner, and that no information was given to the petitioner about any alteration in the date of birth as recorded in the service book. The petitioner contains that the service book of the petitioner categorically records the date of birth of the petitioner as 13th July 1949. The petitioner was never put to notice about any such alteration, and her date of birth continued to be recorded as such in the service book. It is admitted that the aforesaid aspect of the matter, that her date of birth was recorded as 13th July 1949 in the service book, has not been disputed in the counter affidavit. It is submitted that in the absence of any such alteration made therein, the respondents could not have proceeded to pass the impugned order. Learned Standing Counsel, on the other hand, contains that the stand taken in the counter affidavit is that petitioner was subjected to a medical test in the year 1996, and the medical certificate which was issued has been duly countersigned by her, which indicates her date of birth as 13th July 1947. On the strength of the said document, it is urged that the impugned order has been rightly passed, as the petitioner was aware of her date of birth as 13th July 1947, and she cannot now be permitted to challenge the same. It is further indicated in the counter affidavit that during an inspection, the aforesaid fact came to the notice of the authorities, whereafter action was taken and an order had already been passed to refund the salary which has been paid in excess for the period beyond 31st July 2007. Before expressing any opinion in the merits of the impugned order, it would be appropriate to record that when the field is already occupied by a statutory rule, then the authority ought to have noticed the same before having proceeded to take any action. The impugned order nowhere indicates the consideration of the 1974 rules referred to herein above. It appears that the date of birth which was mentioned in the medical certificate dated 23rd April 1996 has been taken to be conclusive proof of the date of birth of the petitioner. The said document is a medical certificate which was prepared at the time of the confirmation of the services of the petitioner. Stop.